Thank you, Mr. Chair. My name is Patrick Smith, and I'm the president of the Intellectual Property Institute of Canada, often referred to as IPIC. I would like to begin by thanking this committee for inviting IPIC to present to you our main thoughts on the legislative amendments, including Bill C-86, and answer any questions you may have. As you may know, IPIC is the Canadian Professional Association of Patent Agents, Trademark Agents, and Lawyers practicing in intellectual property. I would like to begin by mentioning that IPIC supports the government's intentions and stated needs for the development of a national IP strategy to help Canadian businesses compete on the world stage. However, since many of the legislative changes in Division 7, subdivisions A, B, C, F, G, and H, were only consulted upon in principle without discussions on the transition, implementation, or the legislative text, we feel that they would benefit from further discussions with the IP profession and innovative Canadian industries. In order to be able to present to you our thoughts today, we tasked IPIC's subject matter experts to provide a few important recommendations on issues they identified related to the proposed amendments to the IP-related acts. Our committees continue to review the legislation, and we will provide a fulsome submission to you next week with our detailed recommendations. So today's comments are just preliminary. The first issue relates to the need for clarification on the appropriate transition period. And this is important for sections 52.1, 53.1, and 55.3. But we feel the most important one of which is changing the rules for file wrapper estoppel by way of section 53.1. Essentially what this relates to is the ability to admit prosecution histories into judicial proceedings. The change overturns judicial precedent. The transition provision, section 201, makes this change applicable to active litigation, active patent applications, and existing patents obtained under the old rules. Generally speaking, existing rights holders should not have rules imposed upon them that will substantively change their rights, absent compelling policy reasons to do so. The second issue pertains to the replacement of Section 56 of the Patent Act with Sections 56 subsections 1 to 11. When the subject of a patent is previously being used by another person or business, the current law allows the prior user to keep using the material in their possession. After the patent issues, they cannot make more of the infringing material. Section 56 amendments significantly enlarge a prior user's rights. If the change is implemented, the prior user can pass on their rights to another, thereby significantly interfering with the exclusive rights granted to the subsequent patentee. Given that the patent system is predicated upon encouraging inventors to disclose their inventions rather than keep them secret, the amendment to Section 56 is contrary to this policy objective in that it further rewards secret use. Turning now to trademarks. Our members are encouraged by the attempt in Subdivision B to introduce policy to limit trademark squatting. The new provisions allow persons to enforce a trademark within the first 3 years by demonstrating use of a trademark. IPIC believes that this approach is a band-aid solution to fix an issue that was created in 2014 under Bill C-31, which removed the requirement for trademark applicants to show the mark was being used prior to registration. Our members feel strongly that the amendments to the Trademarks Act in Bill C-86 would be better if they simply required a showing of trademark use at the time of registration. With the removal of the requirement for a declaration of use before trademark registration, it encourages trademark speculators, where the owner has no real intention of ever using the trademark in Canada, and allows registrations to remain on the register without being used unless challenged at the expense of another entity looking to use that mark. This completely disadvantages Canadian businesses that have used or have a genuine intention to use a similar mark. Due to increased expense, SMEs in Canada are put at a particular disadvantage. Turning now to copyright. Our members want to congratulate the government in amending the provisions of the Copyright Act for recognizing the instrumental role played by the Copyright Board in shaping the law on copyright in the new digital economy. The objective of the new legislation is to create a more efficient decision-making process. With these objectives in mind, we will be providing written representations on a number of important technical issues. By way of example, the intent of Section 68.3, round bracket 1, is to make clear that the collective may apply to the board to withdraw a tariff or remove an act from a proposed tariff. However, the section as currently drafted may limit the ability of a collective to amend its tariff during the tariff proceeding. There are many circumstances in which, during the normal course of a tariff proceeding, a collective may amend its tariff. As examples, a collective will often seek a different tariff rate once all of the interrogatories are answered and evidence filed. Or a collective may respond to various objections by changing the proposed wording of its tariff. Assuming that the intent of this amendment was to expand the ability of a collective to amend its case with board approval, rather than limit it, IPIC will propose a technical amendment. That is all our comments for the panel. As you saw, some of the amendments are quite significant and can have a large impact on Canadian businesses, especially SMEs. We therefore strongly recommend that the government create working groups to ensure that all amendments are properly analyzed in the context of the real-world application and in collaboration with practicing IP professionals. And thank you very much.